for the second month in a row, free of charge to all of our members. And we're pleased to have Mark Murakami of Damon Key, Claire Connors of Davis Levin, and of course, Judge
Rick Clifton.
Oh. My mind was going too fast. So I'm going to let them go ahead and take it away so we have a lot of material to cover, but thank you for coming.
Hey, good afternoon, everyone. My name is Mark Murakami. It's good to be here. It's one of those careful what you wish for things. When Rebecca asked me about, I think last year, to do something for the appellate section, I said, okay, I'll volunteer months in advance. Of course, then trial gets set for 2 weeks ago, and it actually goes to trial. So I thought, well, I want to sound smart, so we drafted up an outline, and then 2 weeks ago, Judge Clifton announces he's going to join and be a panelist too. Well, now I really have to research and get smart. It was going to be the Claire and Mark Wing It show for you folks.
Now it's the Claire, Mark, and Rick Wing It. Okay.
And then because we did an outline, now we get MCP credit, which boosted up the numbers from 25 to 50 plus instantly. So anyway, the presentation is going to be laid out. I'm going to cover some of the technical aspects on the civil side, but it's largely applicable, I think, on the criminal side. Then Claire's going to talk a little about criminal differences, and then the judge will chime in when he wants to correct us, to edify us with
It's good to be the king.
some tales. So I have a handout that was mostly just a takeaway because I have some links to websites and helpful pointers. First off, and we're going to primarily be talking about Ninth Circuit Court of Appeals here. I do have a paragraph on Supreme Court processes and whatnot, but it's you know, if you're at that level, then I suggest you take a look at the rulebook because it is different. First off, just because you're admitted to the local district court doesn't mean that you're automatically admitted to the Ninth Circuit. It's a separate admission process, as is the U.S. Supreme Court. It's a separate admission process. And so if you ever think you're going to be appearing in one of those courts, it's important to apply beforehand so you don't have the application process while you're trying to have a 30-day deadline. Jurisdiction in the federal courts is in the Ninth Circuit Court of Appeals. Looks a lot like the Hawaii state system. There's the final judgment rule like we have on the state side. There's a couple years back, the Federal Rules Committee created or amended the regime and created Federal Rules of Civil Procedure 58, which has a nice list of what orders have to be appealed from and can be appealed from separate than a separate final judgment type deal. Of course, with every rule, there's going to be 50 exceptions and common law doctrines to provide otherwise. But I listed a couple of the biggies that you'll see in a federal civil practice on when you can appeal non-final orders or judgments. A couple biggies are the preliminary injunction. There's a separate statute allowing appeal from preliminary injunction orders. The Federal Arbitration Act also has a separate appeal. You don't have to get a final judgment to appeal a motion to compel arbitration, an order compelling arbitration or denying arbitration. We had an interesting one, and some of these on the handout are mistakes or life lessons that I've learned in my appellate practice, but we had a situation of post-judgment state garnishment execution type actions that we were prosecuting in federal court based on diversity, and what orders resolving post-judgment orders have to be appealed. Do you wait till you get a separate judgment, etc.? We settled the case out eventually on different grounds, but you have to be very careful and look for that. Ninth Circuit, it's a little unsettled about how to treat some of these orders, and so you definitely have to research that if you have a situation of post-judgment orders that you want to appeal. There's a collateral order doctrine. There's discretionary appeals, which look like State Rule 54B appeals, and those are provided for in the statute, which I've cited for you there. And the final jurisdictional thing I'll talk to you about are agency appeals. Every statute is going to provide different grounds, so you have to look at those if you have one of those situations. Some agency appeals, Howard's practice has them, where you're going from the ALJ up to the Benefits Review Board and then to the Ninth Circuit, et cetera. You're not coming up from a traditional U.S. District Court final judgment. You want to make sure you take a look at those issues. Okay, moving on. Discovery orders are not appealable, and so if you have a discovery order that you don't like, then what you have to do is refuse to obey that order, be held in contempt, and then take the appeal from that contempt order. Anyone willing to do that? Good luck. I'm not willing to do that, and I'd rather just preserve the issue on appeal and litigate it later on the merits. The mechanics of how you appeal, similar to the state side, you file a notice of appeal at the district court. One of the things that we experienced on my last appeal there is that if a different counsel is going to handle the appeal, the trial counsel has to file the appeal or should file the appeal, but they can denote that who the appellate counsel is going to be. So you don't have the situation of, judgment comes down and you have 30 days to do everything, if the appellate attorney is going to get hired, get your engagement agreement, get your retainer deposit cashed, do a withdrawal and substitution type deal. We learned the hard way that the trial counsel should just file notice of appeal in the name of the appellate attorney and handle it that way. Deadline's 30 days from a final judgment or a separate order under Rule 58. It's jurisdictional. If you don't hit that, then you are barred. The Ninth Circuit just does not have jurisdiction. The Ninth Circuit does have a mediation program, and I've had 2 cases that settled with the help of the Ninth Circuit mediators. They're outstanding mediators based in San Francisco. They're very helpful. They can move deadlines around. They can adjust briefing schedules. And so it's been, and they actually will fly to Hawaii to do the mediation if you want. We handled it on the phone between counsel, but I don't know if anyone else has a bad experience with them, but I've only had good experience with their mediator's office. Those papers have to be filed contemporaneous with the notice of appeal. Once the clerk has, the Ninth Circuit clerk gets the notice of appeal, the docketing fee, and the mediation questionnaire, they will issue a clerk's order setting out the briefing schedule for the opening brief, answering brief, reply brief, and the transcripts. And it comes on your electronic filing, similar to the federal court electronic filing. You get the email. If you don't have electronic filing, I gotta imagine it's very difficult to do that because the Ninth Circuit plainly is e-file and e-notify. Typically, the briefing schedule is about opening brief, say, in the 90 days time frame after your notice of appeal, answering briefs 30 days after that, reply briefs about 14 days after that. But again, those deadlines are set by the clerk's order. The Ninth Circuit has an awesome tool for your brief writing, and they have substantive standards of review for every type of case and legal issue and fact issue you'll have. It's on their website. I provided the URL for that, and it takes away the whole research game on, when you're in admiralty jurisdiction and you're appealing a finding of fact, what's the standard of view from the last admiralty case, etc. So I invite your attention to that. Contents of briefs, and perhaps this is something Judge Clifton will talk a little about, but roughly the technical side, it's 30 pages for the merits briefs and 15 pages for the reply. Interesting thing, you can do word counts like all federal cases, and I actually recommend that you do the word count so you don't get focused on just doing 30 pages, because if you do word counts, then you can use nicer font. And font is becoming in vogue about things to talk about. Our firm default is Times New Roman. I know a lot of government attorneys use Courier, and those are 2 of the hardest fonts to read, and a lot of judges are talking about how difficult those fonts are to read. Times New Roman was created by the London Times to push a lot of content at you in a newspaper, and it wasn't really designed to be readable. And so query when folks are paying an awful lot of money, not as much in Hawaii, but definitely LA and Wall Street firms, a lot of money per hour for their attorneys, you want it to be the most readable. And so we have a link to the Seventh Circuit rules, and they have it was about a 5-page handout on typography and different things you should look for. And I think that it's a good thing that they do word counts because you're more willing to have longer briefs and have more readable font. I don't know if that's been your experience, Judge.
Almost everybody uses Times New Roman or Courier, or the former. I wish they wouldn't. There's no reason you have to. And actually tried to publish things within the court by changing to New Century Book or something like that. But because it looked different from what everybody else was creating, of course I got herded back to Times New Roman. It's just harder to read. The one thing I'll toss in about that, 14-point type, which is required by the Federal Rules of Appellate Procedure. As a practitioner, I thought it was nuts. You get, what, 4 words on each page? But let me tell you, as a consumer of briefs, accompanied with lots of even older eyes than mine, we like that, especially now in this iPad world, where most of us are now reading briefs in electronic form. And the iPad shrinks everything. So instead of being 14-point type, it's now down to about 11. And as a result, after years of resisting, I now have a pair of reading glasses. So be it. If you can do anything to make it more readable, do it. And a better typeface is a good way to do that.
We actually shifted for our appeals to Century School Book, and because there's about, there are people who actually love talking about what fonts lawyers should publish their briefs in, but and I'm not one of them. But Century School Book is approved by the U.S. Supreme Court, and it is a pretty readable font, and so that's what we've shifted to. And the other thing about when you're doing electronic brief filing is that if you are going to put URLs, a lot of stuff we cite down to internet websites. If you publish it, if you create the PDF by using Word or WordPerfect to publish the PDF, and then upload that, the URLs are all hot, and so that when the appellate judges and clerks are reading on their iPads, they can just touch the URL and go right there. If you print, sign, and scan it like the way we always used to, they don't have that ability and function. And so if your goal is to create a readable ease of reading experience for the appeals panel and or their clerks, I would take advantage of that. You e-file, it's pretty similar. It's not the same system as PACER and EMCF at the U.S. District Court, but it's pretty similar. If you have a stipulation, as they often can come up, you have to file that as a motion, otherwise it'll get bounced. That's another life lesson we learned about 3 weeks ago. You file it, and then the clerk will call you and tell you, okay, it's been admitted, send the manual bound copies up to San Francisco at this time. And then so you can go do that. Oral arguments, the Ninth Circuit rules say that they'll hold hearings in Honolulu 3 times a year. I'm not sure if they've actually been doing that more or less. They do, I think, 1 in Anchorage, and I think 1 in Portland. There's a couple throughout in every state. I only looked at Hawaii because that's the only place I practice. There was a case, though, it was in the California State Court side where the California Supreme Court wasn't meeting in the Bay Area. They were meeting in LA, and the attorney actually went to the San Francisco, Sacramento, but it was at the wrong place. It was about 3 or 4 months ago, and so you might want to make sure. It's not always, I think the practice is that if you have a Hawaii case, they try and calendar it here, but I don't think it's required to.
The guidelines followed by the clerk's office is that the first priority for Honolulu scheduling goes to cases from Guam or the Northern Marianas Islands. Aren't many of those, but they'd have to have a really long haul to get to San Francisco, so they actually come first. Now that we're having hearings here 3 times a year, customarily February, June, and October, although occasionally it's been moved. And you can check this. It's set a year at a time. Once it's approved in the late summer or fall, it's posted on our website to list where the hearing locations will be the following year. Occasionally, cases are deemed to have priority, or the parties say it's urgent, and so they'll be scheduled for San Francisco. But right now, the vast majority of Hawaii cases are being scheduled here.
And that's criminal, immigration, bankruptcy, civil?
Immigration too.
Yep.
And then the 3 judges make the one trip, and so the panel will be assigned that they're going to handle all the cases.
Right. I mean, every few years there's a recusal and I'll wind up being drafted for one case, but I don't sit here routinely. I rotate like everybody else. And so, inside word, you won't see the same person in rapid succession because for the less frequent, more desirable locations, namely Honolulu and Anchorage, we take turns. There's actually something of a rotation system. So if somebody was here last year, they're probably not going to be here for another 3 or 4 years. For the other locations, San Francisco, there are multiple 3-judge panels each month. The same is true for our courthouse in Pasadena, which serves Southern California. In Seattle, there's at least one 3-judge panel each month and occasionally a second. Portland is actually going down. We had 5 panels scheduled there this year. It's not as many cases. The other cities are as needed and don't regularly go to any other cities, but we do routinely go to law schools upon invitation. So that's why you'll sometimes have a case pop up in Arizona or Idaho or something. It's because the law school there has invited a panel to come. When the Ninth Circuit comes here, it's the usual practice when school's in session, namely October and February. Usually one of the 3 days is held at the UH Law School. A few judges don't like to do that. Our internal rule says that we go someplace outside of our usual courthouse only if everybody agrees. So you may have a time when a panel doesn't go, but that's been the usual practice for the last several years.
And is it going to stay at the bankruptcy court for the foreseeable future?
We'll be in the bankruptcy court for as long as you can figure. We've actually built some, what you call the 6th floor courthouse space in that building. We gave up as a money-saving device because we really didn't use it enough. And so within the bankruptcy court space where they used to have file cabinets, they went to electronic filing a long time ago, so they had a lot of open space. So we actually built some 3 visiting judge offices for Ninth Circuit panels within that space. And so I think for decades, that's likely, as long as the bankruptcy court's going to be there, that's where the Court of Appeals will have its hearings.
And about oral argument, what is your sense about, you're the only Ninth Circuit judge we have, is Hawaii kind of mystified to a lot of your fellow judges of the Ninth Circuit? Should we have to spend a lot of time translating?
Most cases are the same, other than having names that people struggle to pronounce. But cases are the cases. If you have something that involves something more unique to Hawaii land tenure system, for example, chances are pretty substantial that the person reading the brief, and maybe more importantly, the person's law clerk, isn't going to know squat about what you're talking about. So just one of the things that I urge people to keep in mind is consider who it is you're writing for or arguing to. And in this case, if it's going to be a panel of judges who are almost certainly not based here, you're going to have to explain some things to them in a way you wouldn't have to explain to the Hawaii Supreme Court. Doesn't mean you get pedantic and speak down or talk about something that doesn't matter in the case. But if you have something that does matter in the case and something's a little different about Hawaii or Guam or Saipan or Arizona or whatever it is, I mean, occasionally we have community property states within the Ninth Circuit. And it's sensible for lawyers not sure that their judge is going to be all that familiar with how community property works, because after all, we're in federal court, we don't get those kind of issues very much. Tossing in a paragraph or 2, providing some background is a useful thing. Well, certainly applies here if there's anything unique to Hawaii.
Now let's say you have an adverse decision from the Ninth Circuit. One of the your avenues to ask the court to revisit that is en banc review. Now en banc doesn't mean the entire Ninth Circuit court, every judge is going to be on that panel. I think it's 11, and the Ninth Circuit has more than 11 judges, and so it's, I think it's typically chief judge plus 10 or?
Exactly.
Okay.
Chief judge plus 10. Chief judge could be recused, but it hasn't happened in the years I've been on the court. The 10 are drawn at random from a pool that consists of all the other active judges in the court. Right now we have 27 judges in active status. Chief judge is 1, so 10 are pulled out of 26. To that set of 26 are added any senior status Ninth Circuit judge who might have been on a 3-judge panel who had that case before. This is actually by statute, not by Ninth Circuit rule, but it means if you had a 3-judge panel with Judge Tashima on it, for example, senior status Ninth Circuit judge, he's not automatically on the en banc panel, but his little wooden ball, we use the old style wooden box, jury draw kind of thing, he'll have his ball in the box eligible to be drawn. And so the pool consists of the other 26 active status judges, plus any senior status judge who was on, senior status Ninth Circuit judge, not a visiting judge from another circuit, not a district judge sitting by designation. Senior status Ninth Circuit judge who sat on a 3-judge panel for that case, which is how occasionally you wind up with a senior judge. I thought of Judge Tashima because last month I was on an en banc panel where Judge Tashima was there because his name happened to be drawn. He had been on the previous 3-judge panel. The judges are not automatically moved from the 3-judge panel to the en banc panel. As it happens, the other 2 judges in that panel, who were both active status Ninth Circuit judges, were not drawn for the en banc panel. So you just get added to the pool for potential drawing.
So your hope is that the dissent is the one that gets picked and not the... Okay, I have a cite to Federal Rule of Appellate Procedure 35, which has the different bases on which you can seek en banc review. And that covers the Ninth Circuit. One of the things I wanted to shift over and provide briefly was the Supreme Court, the United States Supreme Court, has a discretionary review of all the federal courts of appeal and all the state Supreme Courts. By statute, it also has direct appeal from 3-judge panels, which I think are only reapportionment cases and cases involving the constitutionality of a federal statute is the typically ones where you see a 3-judge district court panel that can have direct appeal to the United States Supreme Court. And the deadline for filing your cert petition is 90 days after the entry of the appellate judgment. The last one I want to talk about, because it is a big part of our practice, is amicus curiae. We don't see that a lot on the Hawaii State Appellate Court side, and I think that we should see more. I would hope that the appellate section and the appellate petitioners take advantage of both the Hawaii State Rule of Appellate Procedure, which allows amicus practice, but as well as the federal ones, because we find that, and it's our hope that when the appellate courts are reviewing these cases, they're not making these decisions in a vacuum, and sometimes, primarily it's trade associations or special interest groups, have a voice that can help contextualize the issue on appeal. And so we routinely do that in the U.S. Supreme Court. I have a Ninth Circuit one. Actually, Judge Kaye let us be an amicus party in a federal court proceeding at the trial court level related to a Second Amendment issue that is now up at the Ninth Circuit. And so it's allowed by the Federal Rules of Appellate Procedure. I think that if you asked most appellate judges, they would find that amicus briefs are helpful when they help contextualize the issue and they don't just rebrief the merits issues. Sometimes amicus want to just put it in their own spin on it, but I think we've seen, I've reviewed a lot of amicus briefs the last couple of years, that the most effective ones are the ones that help to put the legal issue in a broader context, perhaps the economic context, perhaps it's the societal context. I'm not sure if you have any comments about amicus briefs.
They can be very useful. As it happens, I'm working on an opinion now where there's an amicus brief that said something the parties didn't say and was useful. I'd say the majority of filings we get are sort of cheerleader briefs. Okay, we know this party supports that party. We probably knew it before we got your brief. Okay, I can't say that they're well read. You can get the drift pretty quickly, and I'll say this more broadly, but especially in an amicus brief, You want to get your separate message up front. Because otherwise, the chances of getting the reader to flip past page 3 may be slim, especially in one of the kind of cases. I had one in, let's see, in my March calendar, one of those kind of cases must have 15 or 20 briefs, most of which are what I just characterize as cheerleader briefs. That's sort of a waste of time. And so I'm not going to spend much time unless you tell me early on there's something to say here. You're going to learn something different if you turn the next page. So I'm going to say broadly, get to the point. I'm going to say that's especially true if you're the kind of brief that maybe isn't going to be looked at very carefully unless you give them a reason.
Yeah, we had an experience a couple years ago in the Navy sonar litigation that was going on. The litigation made it to the U.S. Supreme Court related to the California training areas, but there was a companion case out in Hawaii related to the Navy's use of sonar and its impact on whales out here as well. And so we did an amicus brief to the U.S. Supreme Court. Interesting thing is, so the Navy was a party, and so the Solicitor General's office was representing the government. And if you looked at their merits briefs, it was all about remedies and NEPA and what congressional intent, et cetera. We represented several retired Navy admirals who had decades of anti-submarine warfare experience. And so, you know, our interest of the amicus parties, part of our amicus brief was huge, talking about all these admirals and all their experience in war fighting. And so what we tried to do is present to the court that, look, when you're reviewing this issue and balancing equities, it was a preliminary injunction type of situation, you need to look at the real world, what's going on with diesel electric submarines and how the Navy training is not just words on a piece of paper and oral arguments. It's, you know, we have 19-year-old Navy sailors sitting in rooms looking at, you know, electronic boxes trying to find people that want to destroy aircraft carriers, et cetera. And so that was one opportunity we took to really inform the court about the real world, about what was going on and the impact that the Navy was training and limitation on Navy training was going to have on its efforts to fight the submarine threats. Anyway, why don't we turn over to Claire to talk a little about criminal?
Sure. So I don't know if I was an add-on thought to this because I don't know how many people are actually involved in criminal practice here in the federal court. So I think the U.S. attorney are doing some kind of criminal defense, which I did not do, full disclosure. I was a former prosecutor. I have a colleague here who was a federal public defender, and he can correct me if I get anything wrong. But I'll just start off by saying just some of the areas to note if you haven't practiced too much in the criminal realm, is that there are some differences in terms of deadlines. For example, you have 10 days, not 30 days, after there's a judgment order entered, and that's you can get 30 days if there's excusable neglect or good cause, but for the most part you've got 10 days if you're a defendant. You get 30 days if you're the government. The government cannot appeal unless the Solicitor General or the Attorney General's office authorizes it. So it's not just favor to the government, there are additional steps that the government has to go through if they're going to appeal anything on the interlocutory level or something subsequent like a Rule 29 or something along those lines. So that's one distinction in terms of timing that you want to keep in mind. You do get to expedite your transcript order after there's a verdict. You can order, you don't have to wait for there to be a judgment entered, so you get to get that going, especially if it was a lengthy trial. There's another component to the criminal practice too, which occurs actually in the civil realm, but it's the 2241, 2255 motion. So after you get your judgment affirmed, hopefully, then there's a whole nother realm that the defense can go through, the civil realm, where they can go and say under 2241 or 2255 that I'm in here and I don't belong in here, the judgment, the sentence, all that was imposed improperly. And the Supreme Court has weighed in a lot on the habeas corpus provisions, so I just caution you to take a look at it. There are different deadlines that apply in terms of time frame. And I think there also have to be certificates issued by the district court or the appellate court as to whether or not those can proceed. So there's a whole lot of other things to consider in that realm, but it is something that when you're doing criminal practice, it's likely to come up, especially on the government side. There's the same thing with interlocutory appeals as there is on the civil side. They're not favored, but there are definitely instances in which it comes to bear. In the grand jury process, which I was largely involved in, if the court quashes one of your subpoenas, you can appeal that. If you compel someone's testimony before the grand jury, that's appealable. There are certain things in the grand jury context that are immediately appealable. There are also a series of detention issues that come up. If you have been detained pending trial, and there's an order there, that's immediately appealable. If you are detained pending resolution of your appeal, that's also immediately appealable. If you are found not to be competent, obviously, and therefore you're committed, that's immediately appealable as well before there'll be a subsequent trial or adjudication, so that's obviously the reason. There are also some technicalities. If you are going to be serving fewer than 12 months of your sentence by the time this whole thing gets resolved, then there's certain consideration given to you as well, because it might take 12 months to resolve the matter and you'll serve more time than maybe needed to. Double jeopardy is a big one. Obviously, the government can't appeal if there's an acquittal, but prior to that, it can appeal if there's been a dismissal of its indictment. If the court, and this has happened in the U.S. Attorney's Office, just the court thought it took you too long to indict, you can appeal any dismissal of your indictment. You can appeal a Rule 29 judgment if you've preserved it and there's a conviction. And same thing for Rule 33, which is a motion for new trial. You have to have a conviction, obviously, for that to be something that the government can appeal. But the defense, they'll want to move for double jeopardy if there's been a prior prosecution. And that denial of a double jeopardy is immediately appealable as well, for obvious reasons there too. You're not to be tried twice. Another thing that you do get suppression issues. Those are something if a large chunk of the government's case gets suppressed for Fourth Amendment issues, that's immediately appealable because sometimes that's your whole case. So that's something that that does get litigated and is something that the government will have to really ferret out. And I've seen it also where the defense has appealed if there's a denial of the suppression motion too. I think the standard's a little bit tougher, but yeah, that's happening as well. So generally, I was talking about this 10-day notice requirement to file your appeal. Generally, it's the counsel who was the trial counsel who has that obligation. If you're being represented by the PD's office, they generally take the case straight through. The CJA panel, the government appointed, generally do not. So they will generally still bear the obligation of meeting that 10-day requirement. And then at that point, there'll be some substitution of counsel that'll take place, and then you'll get CJA appointed counsel to do the appeal. I think there's 2 who generally do them now. But that's important. It remains the obligation of the trial attorney. The appellate attorney for the defense who comes on board has to review the case. There can be a filing of an Anders brief, which is if that appellate attorney comes on board and says, I don't really see any substantial issues here, they file an Anders brief, and that is a big clue to the court that there's issues that this defense attorney has thought were not there, but it doesn't actually preclude. The defendant can proceed pro se, and that happens a fair amount too, and there's a whole set of rules when that pro se process comes into play that take effect. But the district court will always retain jurisdiction to correct a sentence under Rule 35. So I guess there are instances in which that plays against the larger fabric, but that is something that the district court can do. But I actually haven't been a part of that, aside from the motion for recon and things like that happened prior to certifying the appeal. I think before Judge Clifton came on the panel, we were going to talk a little bit about some of our tips too, but I think Judge Clifton can tell you what he wants to see. But so I've done some civil, but did quite a bit of criminal work too. The brief is obviously, in my mind, the most critical place where you set your arguments and where you put together your case. It's the opportunity for you to step back, to focus and distill. So especially if you're in trial, there's so much stuff coming at you all the time with new evidence, newly disclosed theories, all this type of stuff. When you get to the appellate level, it's a good time to just stand back. And in the prosecutor's office, we did everything. We did our own trials, and we did our own appeals as well. So you had some unfortunate learning lessons on the appellate side, but you know, if you were wise, you can learn from others more than your own experiences. But that's that was a good experience because it really then made you focus even more on preserving what it was you worked that hard for. I would assume that everyone moots their arguments. I think that's I hope something that everyone does. I know sometimes when it's criminal defense and there's money at issue, maybe it's not something that everyone does, but don't do it the night before, do it the week before, because you want to be critiqued, you want to have people say that doesn't make any sense, or the way that came out, did you mean this? I mean, you really want that process and you want it to kind of sit and meld, so by the time you get there, it's pretty facile and pretty, you own it, and you've been critiqued, and you can anticipate what the judges might be throwing at you. I feel, again, a little chagrined saying anything else with the judge right here, but yeah, I mean, with the, was there anything else? The standard stuff, you know your record cold, know your case is cold, having been a law clerk. That's something that the clerks in the gallery are looking for. They, respectfully, could you look at page 1505? This is where that piece of evidence was set forth. This is where that exhibit was. And I was a law clerk in the back, scribbling down those citations just as much as I see them scribbling citations when I raise those issues. But you want to know your case is cold too. And the way I prep it is every single argument that I've got has the main cases, the main points in the record where it is. So I just own that by the time you're up there and you're able to converse. And then oral argument might actually be fun because you're really engaging in sort of a nice examination, a very interesting examination of a case that you've worked a lot on from the beginning right up to that point. So I think that's, unless anyone has a specific interest in criminal.
Judge, will the appellate judges have looked at the cases before, or do they have a bench memo type deal where they'll, before oral argument, I guess is what my question is.
90% of our work precedes oral argument, at least the Ninth Circuit. I think the vast majority of courts of appeals today, certainly the Ninth Circuit. We work the cases up in advance. And maybe more importantly than that, not just us, but our law clerks work the cases up in advance. The Ninth Circuit uses a pooling system for bench memos. All but 2 of our judges participate in it. There are a couple who don't. Which means that, assume for a moment you've got the luxury of the same 3 judges on the panel all week. It really doesn't happen that often, but it makes the math simpler. So you have your 30 to 35 cases assigned to you. We use a point system, not a number of case system, so the number can vary. Each chambers will be responsible for preparing a comprehensive bench memo and circulating it to all 3 chambers for approximately 1/3 of the cases. My chambers and all the other offices that I know about have a law clerk assigned to each case. So when I'm getting a bench memo in from, I mentioned Judge Tsushima again, get somebody in my office working on it. And that's probably true of the 3rd judge too. So you're going to have 3 judges and 3 law clerks working on it pretty intensively in advance of argument. And that's why what Claire said in terms of the brief being by far the most important piece is right on. It's nearly impossible to change the bottom line result starting at oral argument, which is something, in retrospect, I realized as a young attorney. We're writing the briefs. Of course, the senior types would come in and they're going to take care of the argument, and they were involved in varying degrees in the brief. Well, they're kind of wasting their time, because if the brief doesn't get where it needs to go, you're not going to save the case at oral argument. The brief is what really counts. And we put, like I say, 90% of the work in before the argument. The form of disposition, if it turns out to be a published presidential opinion in some new area, you may wind up having a lot of time on the case. But otherwise, we've pretty well decided coming into argument, you don't tell us anything that causes us to change direction. Argument does sometimes change direction in terms of what you talk about, and sometimes you learn new facts. But it's really pretty rare for oral argument to come in and cause the panel that was otherwise inclined to affirm to decide to reverse. So I think I'm pretty confident that all of my colleagues share the same approach. We are a very hot bench, and not not an argument week goes by when I don't see some lawyers kind of surprised that we ask them questions about something that they're not talking about, might not even be in the brief. And it's embarrassing the number of cases where it turns out we know the record better than they do. Either because they didn't bother to learn it that well in the first place, or it's been a year and a half since the trial and they're trying to wing it based on what they remember. Well, we're not doing that. We've looked at it more recently. And maybe most importantly, and I emphasize this, we've got all these bright, energetic law clerks who like nothing better than collecting lawyers' scalps and putting them on the wall. So if you think you can put one by the batch of old folks, maybe you could. But you're not going to get it by the energetic 20 to 30-year-olds who are really determined to show that they're so much smarter than all these lawyers appearing in front of us. So, yeah, assume we're going to be real prepared.
Judge, maybe you could comment when we were crafting those briefs. How persuasive are sister court of appeals in other jurisdictions authority versus legislative intent versus state court, Supreme Court decisions? Is there a hierarchy perhaps that you personally have?
We are bound by statutes and the Constitution, decisions of the U.S. Supreme Court. And the Supreme Court's made it very clear that we're not supposed to anticipate the possibility they will change their direction. So even if there appears to be a Supreme Court doctrine on life support, it's not for us to make the change. We are bound by it. We are bound by decisions of the highest court of the state in matters involving state law. And we have a lot of matters involving state law. So as to that, it's the Supreme Court of Hawaii, or the Supreme Court of California, or whatever jurisdiction we are bound by. And we are bound by prior decisions of our own court, which means one three-judge panel can't change what some other three-judge panel decided, even though we all know those guys were out to lunch. We're bound by it. I won't pretend that there aren't sometimes some creative distinctions drawn. But we try, I think, to play it straight. The one exception, there was an en banc decision about 10 years ago. It gets cited a lot. It's called Miller versus Gammy. If you get into the situation, you'll find it. It has to do with when can one three-judge panel abandon a prior Ninth Circuit precedent based on what's happened in between from the Supreme Court or statute. The answer turns out to be it doesn't have to be absolutely explicit. If Smith versus Jones is out there, even though the Supreme Court hasn't actually reversed Smith versus Jones, if it said things such that make it clear that Smith is a dead letter, then the next Ninth Circuit panel is supposed to come along and recognize that it's a dead letter. But we try to be pretty careful with that. So for the most part, I think you should assume if there's a prior Ninth Circuit decision, it's binding, and if you think there's a reason it shouldn't be binding, be very specific with the reason. And people coming in explain to us why it was a bad decision, which I see occasionally. That's not going to do it. If you think it's a bad decision, all the three-judge panel can do is refer it to an en banc panel. The en banc court has the power to overturn our past precedent. And we do that. And occasionally panels, I was on a panel last year that said, look, we've got this precedent that just plainly is out of touch. Now all the other circuits have gone the other way and so forth. But it's not in contrast to some intervening Supreme Court decision. It's just, we're up against a wall. We suggest the court rehear this en banc, and it did. We rehear about 20 cases a year en banc, and I'd guess probably these are pretty, the 20 is actually pretty steady. In my now 11 years on the court, I think it's ranged between 15 and 25 every year, probably because that's our tolerance level. And I'd guess of the average 20, probably 4 or 5 are conflicting lines of precedent without realizing that one panel's gone this direction, another panel's gone that direction. Here we got a conflict we have to resolve. And maybe another 4 or 5 are what I just described, maybe more like 2 or 3. Panels that say, look, we've got this precedent, it just doesn't work anymore. The rest of the cases are the court as a whole not liking the judgment of a particular three-judge panel or thinking that their creative distinction was maybe a little too creative and trying to avoid past precedent. not many cases get taken on bond.
Question?
That Pledge of Allegiance case that went on bond.
Well, we've been through the Pledge of Allegiance lots of times. The most recent one did not. And they're brought by the same plaintiff, Michael Newdow from Sacramento, who is a non-practicing JD. He's a doctor. And the one that got all prominence, and I'm vividly familiar with this because my nomination wasn't controversial, ultimately got confirmed 98-0. But even then, people talk about how long the process takes now. It was over a year for me, just kind of sitting around waiting. And the period of time between being approved by the Senate Judiciary Committee and being confirmed on the floor was unusually long because of a fight having to do with the Federal Communications Commission. That's the Senate. So I'm sitting there, and your practice kind of dries up when you get nominated to the court, because let's face it, you're not going to get hired because you're going to bail on these clients, and they know it, right? And I was fortunate to have had tolerant partners, so I'm sitting there, I worked off my caseload, but toward the end, I'm spending a lot of time surfing the web, because what else you got to do, right? And so I have C-SPAN on all the time, because I've been told at one point they could just bring it to the floor whenever, and there's no controversy attached to it, they just got these cumbersome things. And I happened to have C-SPAN on with the Senate when the Ninth Circuit came out with its first Pledge of Allegiance decision. And I watched the stream of senators. I'll just make the observation, most of them being liberal or progressive Democratic senators who wanted to make clear that this isn't their decision, come to the floor and denounce the decision in the Ninth Circuit. So I scream at the computer, so confirm some more judges. But, ultimately, the Supreme Court threw out that decision on standing grounds because it turned out that Michael Newdow was the father of the girl in question who attended the Elk Grove elementary school, but he had no legal custody rights. And when it hit the fan, which is after the Ninth Circuit decision, the mother was appalled and said, my daughter doesn't regret or doesn't not like standing up to say the pledge. Whether it was because she didn't want to be singled out for her friends, I don't know. But anyway, she pulled the plug, and the Supreme Court said there's no standing. The plaintiff didn't have standing. It was an obvious dodge, not wanting to deal with the issue. I teach from time to time at the law school. I taught years ago and stopped when our son was born because I just had too many things to do. Dean Soifer's a friend. He knew when our son graduated. So he pounced then, and one of the things he said is pick a subject area that you have cases on, but you'd like to know more of from a non-case perspective. And the Establishment Clause is like the first thing that came to mind. So I've had a bunch of cases, and I couldn't make any sense out of the Supreme Court's case law. So I taught a seminar a few years ago at the law school on the Establishment Clause. What I learned is it wasn't me, it's them. That case law is incoherent. It's just inconsistent in lots of respects. And it was clear they didn't want to deal with the Pledge of Allegiance, so they didn't. And when it came back to the Ninth Circuit again with a plaintiff that did have standing, a different Ninth Circuit panel decided that the pledge was not unconstitutional. And oddly enough, the Supreme Court decided not to grant cert on that decision. They don't want to touch that at all.
Are there some vacancies in the Ninth Circuit?
2. We have 29 active positions. It had been 28, effective with President Obama's inauguration day in 2009. One more seat was added, and one seat was taken away from the D.C. Circuit, which hadn't been filled in years, in an effort to broker a compromise over a dispute between the senators from California and Idaho over the Steve Trott seat. Steve Trott is a now senior judge of our court who's probably the only, I say with some confidence, the only federal appellate judge who's been on the Billboard Top 100. He was a college student at Wesleyan back in the early 60s, was a member of a group, I can look around and tell the age group here, right? You guys are going to recognize the Highwaymen doing Michael Row the Boat Ashore, which was #1, and Cotton Fields and several other chart hits. And then they graduated, and one went to law school, and one went to medical school, and one became a banker and so forth. One stayed in the music business. And then they revived a few years ago, and for a while were traveling again. Anyway, he was appointed to our court at a time when he was in the Justice Department. He had been the U.S. Attorney in Los Angeles. He'd been a county prosecutor in Los Angeles. His whole career was there. But after being appointed from DC, he and his wife decided they didn't want to move back to Los Angeles, so they moved to Boise. And when we took senior status, the senators from Idaho took the position that that seat should go to somebody from Idaho. And the senators from California take the position that seat belongs to California. That seat's now been vacant for going on 8 years, and efforts have been made. They promised to dig up a liberal Democrat from Idaho, and the California senator said no. They promised to try to find a conservative Republican from California, and the Idaho senator said no. And so Senator Kyle from Arizona, who retired, didn't run for re-election last year, tried to broker a compromise by adding a seat. That's how it got shifted from DC to the Ninth Circuit. Figuring, okay, you'll both take one. No, California claimed both. So that seat remains vacant, and there's no sign that it's going to be filled. Another seat became available on April Fool's Day. Ray Fisher from Pasadena took senior status effective April 1st, and so that seat is now open, available for appointment. I am not aware of, there are a few judges in the court eligible for senior status. I'm eligible for senior status 3 years, 6 months, and 29 days from now. But I am not, nobody has, they ask you to announce your intentions a year in advance. Nobody has announced intentions. Some do announce it with less notice than that, but right now, I expect the Judge Fisher vacancy is likely to be filled in the next year. I'm not holding my breath for Judge Strott's seat.
What is the impact of California on the Ninth Circuit?
Well, it's over 60% of our cases, and it's over half our judges. The proportion of judges is less than the proportion of cases or the population. That was the big problem behind all the discussion of splitting the circuit into pieces. There's just no sensible split if California remains whole. The last set of proposals would have, unless you want to divide a state, and people are pretty firm against doing that, or have a state be its own circuit, people are fairly firm against doing that, and so all the proposals have California and Hawaii put together, which when I saw the list of judges made me feel proud that I was the embodiment of federalism. That was it, right? So long as I didn't have to sit on every single case, that was fine. Nothing's happening with circuit split. There's been no discussion of it for years, and nobody expects it to come back. The principal proponents have mostly left Congress. The one who was strongly behind it, Representative Sensenbrenner from Wisconsin, is still there, but he's no longer chairman of the Judiciary Committee. So it's not expected anything's going to happen.
Do you think it had any merit?
No. The vast majority, the substantial majority of judges in our court were against it. The problem isn't that we're too big. The real problem is that some of the other circuits are too small in terms of efficiency. I think we're larger than ideal. We're the only court that uses the limited en banc process. Congress passed something in the late 70s when they enlarged our court to 23 positions that said a court over a certain size, and I think it's 15, could adopt a limited en banc. And the 11th and 5th circuits have now crept to that point, but haven't done it. The 11th circuit, which is Florida, Georgia, Alabama, is resisting the addition of more judges for fear of the size. They're just trying to process their cases faster. We are larger than an ideal court, but not that much larger. And there's some advantages of scale. One of the things we do, for example, and people have asked, so let me start this. I've been hoping for months to be able to attend a meeting of this section, in part because I'd like to be available for people to ask questions more commonly. I'm kind of the only game in town for the Ninth Circuit, so if you want to find out what happens, I'm kind of it. The problem is that I'm gone a lot. Like, I'm here more than half the time, but it just worked out over the last several months that I never coincided with any meetings. So when Rebecca told me this is going to be the date of the meeting, great. And then she told me what the topic was. Well, okay, that's me too. I didn't really mean to take over the stage. but I want to be able to answer questions that people have, not just today, but at opportunities in the future, because it's still my intent to try to come to these. I can't talk about particular cases, but I want to be able to ask questions, so I'll stick around for a few minutes afterwards. I realize it's 1 o'clock, so what I wanted to get to real quickly, things that I'm going to keep hammering in. If you heard me before, you've heard them before. When you hear me again, you're going to hear them again. But things to keep in mind for going to the Ninth Circuit. And in particular, the substance or the presentation of your brief and your oral argument. 3 rules. The first, get to the point. Most people use word count for briefs. The word count, there are some exceptions, but generally the word count for opening answering brief, 14,000 words. Entirely too many briefs are 13,975 plus words. And when I used to read in paper form, I could tell when I picked it up. Now it's electronic. When I turn the page, it reports the number of pages left. You know, I'm on page 14 out of 75. Gee, this is a little case. What are they doing? I mean, they can make me turn the pages. They can't make me pay attention. And a lot of things are competing for our attention. Chief Justice Roberts was asked at a judicial conference a couple years ago what he'd do to change practice at the Supreme Court. His first suggestion was to give the Chief Justice 2 votes. That's probably not going to work. But his second is that he wished lawyers would emphasize their main points. And I highlight this because this is one of the things where I have to say I was a offender when I was in practice. I mean, this case is really important to me, so I'm going to say everything that I thought needed to be said. But this is one of a whole lot of cases that judges are reading. And if you take a long time to build up to the important point, you may have lost them along the way. Something that's succinct and concise and punchy has more impact. So it's really worth your while to get to the point. That doesn't mean you skip all the other stuff, but get to the point up front. I mentioned the real critical need to do that in an amicus brief because we really don't read all those things. I don't. My law clerks have to, and I tell them to let me know when there's one that matters, but otherwise I'm going to start. And if I got to stack a dozen, the case is public, it's a case out of Montana. The Montana legislature has passed its Firearms Freedom Act or something like that, basically trying to say if you build a firearm in Montana, out of Montana raw materials, label it made in Montana, so on and so forth, you can do that, says the Montana legislature, without regard to the federal firearm laws. I'm not going to comment on the case's substance, but we got lots of amicus briefs. Most of them weren't really worth the pixels they were. And so, if I got a stack of amicus briefs, I'll just assure you right now, full confession, I'm not going to spend a lot of time reading all those briefs carefully. There aren't many cases like that. There aren't many cases where you get a dozen amicus briefs. But even in the regular case, you're the opening brief, you're the answering brief, you can be pretty confident, yes, I am going to turn all the pages. But it's a lot more effective if you really get to the point, put it right up front. And I mean both in organizing your argument and have an introduction or a summary of argument and use your table of contents as an outline of the key points. Remember, on a given day, we got 5 to 8 cases set for argument. We may not hear argument in all of them. It's hard to keep them straight. So if I want to look real quickly, which case is this? What are the arguments? Make it easy for me. Use the table of contents. I mean, I'm shocked the number of cases I get. I'm shocked now. I wouldn't have been shocked then. Where the table of contents, which is required, says standard review, summary of argument, statement of facts, statement of the case, argument, conclusion. What about the nature of the argument? What are your points? Not there. Make it a detailed outline. I mean, don't make it 5 pages long with every subpoint, but give me your main themes right there on the table of contents. Give me your main themes at the introduction or summary of argument. Harp on those themes. You don't have to say it 17 times. We're smart enough to pick it up by 3 or 4. But get to the point. That's number 1. Number 2, this is a corollary, simplify the case. Most lawyers continue with the case trial to appeal. What Claire was talking about, the practice of the U.S. Attorney's Office. And that's fine, although you want to look at the case with fresh eyes. You don't want to just continue the brawl. Think about what it is the Court of Appeals might be interested in. Particularly if you're the appellant, you're probably not happy with what happened before. What should cause the Court of Appeals to decide something different? We get a lot of cases, not the majority, fortunately, but a lot of cases where you got these two attorneys kind of duking it out. I feel like I'm watching them. They're fighting about things they've been fighting about for years. Just kind of roll across the courtroom. They're going to go out the other side. And I don't care about how you were abused in discovery. We became Court of Appeals judges so we wouldn't have to deal with it. So look at it fresh. Okay, we got this decision. Remember, 80% of district court decisions are affirmed. And that's not just because they're nice guys. Some of them aren't. But they get affirmed because usually they're right. So you got to give us a handle. You got to give us a reason for why it is we should take a different look at it. And one thing you should do is take a different look at it yourself. Maybe if you've been fighting the same battle, you're not fighting the right one. Now that doesn't mean come up with new issues. You haven't preserved it, exhausted the issues and so forth, you're going to have problems. But try to take a fresh look and try to simplify the case so you can, in ideally one sentence or one paragraph or the verbal equivalent of that, explain why it's the right thing for you to win. And ideally you can do this with somebody who's a layperson, not a lawyer. Because if you can explain to them why you should win, you got a much better chance of persuading the judges why you should win. And there are lots of good things about being a judge. One of the best is, for the most part, you get to do the right thing. Not always. Sometimes the law produces a result which, in its wisdom, which obviously isn't as great as mine, I don't think is the right thing. But for the most part, judges are trying to do the right thing. And so if you can give them a reason for why this is the right result, and I don't mean a jury, hearts and flowers, emotional argument, and I might mean an argument that says, look, the rules have to be protected. This deadline's lost. It's jurisdictional. It was filed too late. That's it. That's an argument why the result you're seeking is the right thing. But try to give us a succinct, concise, one paragraph kind of explanation for why it is you should win. And then play that card early and often. Get to the point, simplify the case. Third, keep the target audience, the reader, the listener, in mind. And that's the 3 Court of Appeals judges or judges sitting with the Court of Appeals and their law clerks. We talked before about what happens if it's a Hawaii case. Well, if you don't expect the audience to know about the case, you got to give them some background. If it's a somewhat unusual case, we're generalists. If you give me an immigration case, if you give me a habeas case, most criminal appeals, well, most of us get the hang of that pretty quickly. We see so many of them. But it doesn't hurt to keep in mind that the law clerks probably haven't seen all of them, and they're going to work on the case first. So trying to do it in a way that's not insulting, providing a little background is never a bad thing. If I know what the standard of review is in a habeas case, and you can bet that I do, not hard for me to flip past that paragraph and keep going. But the law clerk might not know. And so a little explanation, keeping in mind the judges and the law clerks, is a good thing. Mark talked before about the standard of review manual. You'll find on our website manuals prepared by staff attorneys on several subjects. The one that will be interest to the largest number of people is standard of review. It's not at all binding, not citable, but it does a pretty thorough job, and the staff attorneys update it every year, of cataloging Ninth Circuit cases as to the standard of review. The other areas we have those: immigration law, habeas law, Social Security disability benefit appeals, and so forth. They're all public. Go look. Don't cite them, but take advantage of the fact that somebody's done a lot of legwork gathering Ninth Circuit cases that might be applicable to your case. So get to the point, simplify the case, keep your audience in mind.
Probably have time for one more question before Rebecca cuts me off. Anyone else? Okay.
Do you want me to start asking questions? Counselor?
I want to thank you all for coming again. Because this was the required credit, we need you to sign out on the sign-out sheet, and then you can pick up your MCPE certificate. For those of you who don't know, we are doing a federal appellate manual. Two of our speakers today, Judge Clifton and Mark, are also contributing that as in addition to a number of our other section members. So that will be available at this year's bar convention in September. So thank you. Please come again. And if you didn't get cookies or snacks, they're in the